Pretty new live here from Houston, Texas, every Tuesday from 5 p.m. to 6 p.m. We do bring in immigration update. Along with me is my business partner, Rebecca Chen. Rebecca, what do we have today to discuss?
Yeah, so we'll discuss EB-1A revocations that we have been noticing USCIS issuing in cases where basically some of the criteria, eligibility criteria in those EB-1A petitions were obtained through agencies that essentially faked those credentials. So we'll discuss those. The LA immigration protests that have been in the news and the ICE raids, we'll discuss what legal non-immigrants need to know. And we'll also discuss the grace period for non-immigrant workers and how severance pay factors into that. Can it essentially extend your grace period in those situations potentially? So Rahul, what have we been seeing on these EB-1A revocations?
Let me first explain, Rebecca, that I've seen a very big amount of spike on the EB-1A applications. I've seen that. And I've seen a lot of advertisement in the social media, particularly targeting the Indian clients, though. And they were some successful people. There were many successful people where they got their EB-1A approved, and most of those people have probably moved from the EB-2 to EB-2 or EB-3 to EB-1A, got the green cards also. And definitely that encouraged a spike in the number of other people applying for EB-1A. Now, of course, the EB-1A eligibility is, if you get a Nobel or Oscar, you're automatically in. You don't have to do anything. You just have to show the award. Then if not, then there are 10 criteria, out of which you might at least meet 3 of those criteria. So I have seen a lot of advertisement. Initially, they were advertising for 10,000. Then they're telling that it's going to be 30,000. A lot of advertisement in the social media, and they clearly tell that you don't have to be extraordinary. You don't have to do anything. We'll make you everything to get the EB-1A approval. I made a fake call to these people to understand what they are discussing. It seems to be some of them are operating from India. And I just pretended that I have a University of Texas, Austin master's degree in computer science, and I do work for Dell in Austin. And I don't have any publications, any patent. I have about 7 years experience. And I want to convert from EB-2 to EB-1. And they said, I asked them, how does the process work? Do I have to write the articles? How much time? And they said, no, sir, we have content writers that will write for you. And they said, what are the other criteria? How are you going to get the awards? And they said, no, there are a lot of places. We will tell you how to go, and you just have to apply for the award, and then we guarantee that you will get the award there. These kind of things I've heard. That's very strange to me. Is that nobody's going to buy these kind of things. Then later on, when I noticed recently that there are a lot of people who are an EB-1A, they're getting the interview notice. And recently, a couple of I-140s were being revoked after they have been approved. Once they found out these are not from these people don't have the credentials to get the EB-1A approved. In fact, the revocation of the I-140 came with misrepresentation. That means that these individuals have paid money to get these awards, paid money to publish these articles, have not written these articles by themselves. These should be published in professional magazines, and the award should be internationally acclaimed awards. And that definitely I started investigating more deeper into it. Then I found some of these agencies that have recommended a site. It says, Emily has a Globee Award in our office, right, Emily, Rebecca, that whoever does a better performance in that particular time, we get $1,000 bonus. Of course, Emily has. Similar to that, there is a award that these people were getting. And when I looked into the website of this particular thing, though, oh my goodness, I was shocked, though. They were charging anywhere between $300 to $800 to be getting the award, and they were also you have to pay the money to be the judge there. And when I looked into their different artificial intelligence, some revolutionary awards, these kind of awards, and I have seen the number of people who are getting awards in this website, and I was staggered to see there are thousands of Indians who got award these things, and so thousands of these people are also judges, though. And almost all of those things seems to be, all of those people seems to be, most of those people seems to be Indians. How did I come to know is when I spoke with a couple of people and with consultations on EB-1A, and then I wanted, because of the I-140 revocations, I wanted to look into what kind of awards you submitted. When I looked into these websites, it was staggering, the way that these people just take the money and give an award. Take the money and give the award. I don't know if there is any criteria there. I'm looking at the website there, and there are thousands and thousands and thousands of people. Now, what happened with this is that these people paid between $10,000 to $30,000 to some agency. Most probably they are operating from India, and they are working. They have, I don't know whether they have created this website or they contribute to this website, and they have the content written by them, published, help publish them, and then also they tell the people, you go and you request for an award from this particular place because you have written this article and so on and so forth. When they pay the money, they're getting these awards. Um, Emily was telling that recently the USCIS have hired some softwares to detect all these fraud, and I think so that's the reason why we are noticing the I-140 revocations that were already been approved. We have also seen the 485s getting interviewed and questioned about EB-1A criteria. Are they working? Do they belong to EB-1A criteria? Because previously, whenever the EB-1A, we very rarely we used to see an interview, we used to get the approval though. So a lot of those interviews are scheduled in the coming weeks. So we'll come to know more about if they are really going after these people. But yeah, we started seeing I-140 revocations already for a couple of people, and Ryan is working on seeing if he can do anything on those things. Rebecca, how difficult for a typical guy to get an EB-1C approval? Because I had told some people that somebody says I have 10 years experience, I have a master's degree. I said, well, that's not good enough for you to get a EB-1A approved. And they went in within 6 months, they're able to get the EB-1A approved with these
Yeah.
agencies.
So I will say we are already noticing a pretty significant shift in the current administration's approach to EB-1A and NIW applications. We did see kind of an expansion of these categories under the Biden administration, and there were executive orders, announced by the Biden-Harris administration early on that specifically kind of instructed officers to take into account work in STEM fields, work in AI, and other fields, and specifically tied them to, O1s and EB-1As, NIWs. And so there was a push under the previous administration to what it seemed like to expand kind of the scope of who qualified for an EB-1A or an NIW, depending on the work they did. And so a lot of people were able to benefit from that who maybe previously didn't consider themselves eligible for those criteria. We are, even though it's only been barely 4 or 5 months of the current administration, the RFEs that we're seeing for EB-1A applications, for NIW applications, are already kind of indicate a shift in tone, whereas previously, sometimes, if out of the 8 possible criteria, our applicant, we, argued for 5 criteria, and we know that like 1 is maybe a stretch, but, we're going to put in everything that we think that we can argue for. And then in the RFEs previously, under the previous administration, a lot of times what the RFEs would do with the officers would concede, okay, we concede that you've met this criteria. But we're asking for more information about criteria 2 and 3, or something along those lines. They would at least, it seemed like they were reading it, and if someone clearly qualified for one criteria, they would concede that in the RFE, and then they would go on to indicate what they were questioning, the other criteria they were questioning. Some of the RFEs and denials that we are seeing now are just questioning every single criteria, no matter what. And it's kind of clear from the tone of some of them that some officers are viewing them with the approach of they don't want to approve it. So there is definitely kind of a shift and a higher amount of scrutiny as we're seeing. And these are kind of cases that are not even that are not related to these agencies that we're talking about. So this is even for, kind of perfectly straightforward cases that are not involved in any kind of potential fraud or misrepresentation. But it does just show kind of the higher level of scrutiny and what seems to be the current administration's intention to narrow potentially the scope of eligible EB-1A and NIW applicants, unfortunately.
So, Rebecca, if misrepresentation is a leak, though, if USCIS revokes I-140, misrepresenting I-140, what are the consequences for them?
Yeah, it is. Mhm. It is very difficult. So if the application is already approved, then they would send a notice of intent to revoke, where they should detail the bases for their intention to revoke. And if it is eventually revoked or denied on fraud or misrepresentation grounds, it is very difficult to overcome. It's even if the I-45 has been filed already, and even if it's been pending for 180 days, and it's none of that matters anymore. If it's revoked on fraud or misrepresentation grounds, it's very difficult to overcome that kind of allegation.
And even if you are an H-1B, the H-1B extension may be denied because if the fraud of misrepresentation. So anybody who is intending to hire these agencies to do the content writing or do pay the money to get the awards or obtaining these documents because you're paying the money to some agencies, definitely stay away from these agencies, though. It's not good for you if you are having a caliber. Let's say, for example, if you are having some patents, let's say you're working for some companies, your big companies, let's say you're working for Texas Instruments and you have some patents. Definitely those kind of things, definitely you should work with a competent lawyer and then should highlight those kind of things so that you can tell that you are extraordinary ability. But if you don't have an eligibility, you go to these agencies, they are creating all these content writing and they're telling you to publish and they're telling you to get the awards in this so-called pay to get awards. Definitely it's going to affect you in the long term. Don't go with these agencies. Rebecca, we have seen a lot of protests going on in the ICE, though. What do you advise for our clients, because our clients are all legally staying in the United States? What do you advise for them?
Yeah, it is difficult. It is kind of difficult to parse out, what is going on. There are different allegations on the government side of the protesters being violent and on the protester side of the government using excessive force. In general, for legal non-immigrants, it's best to kind of just probably stay away from those types of situations. What do you think, Rahul?
Yeah, if there is something, we do not want you guys to protest it, though. If you want to do it, you can do some other way, but don't go near those facilities that are having raids. Definitely don't stay there. We recommend that you do not physically go there to protest, to do anything, those sort of things. We have seen when some of the people in the students' agitations where they have gone in rallies in support of Hamas. At that point of time, we did strictly told people stay away from those things. We know what happened to those students, those who went to the rallies. So we definitely don't want you guys to go into those rallies. There are some times where legal rallies were being conducted. For example, removing the per country quota. They got the permission. They went to the rally. Those kind of things are perfectly fine. But these are not, they do not have any permission. We want you to stay away from those things. This is not affecting the legal immigration. In fact, I don't know, the entire media is projecting as if that the immigrants have taken over the country, which is not true. We know we are very legally abiding people. We pay taxes, we apply, we make the applications, we get the approvals, we stay within the norms what are being prescribed by USCIS. and all other laws that exist. So definitely, there's a wrong portrayal is going on about the immigrants, but there's nothing much we can do right now. We do not want you guys to go protest either this way or that way. Don't do that at this point of time. Stay away from those places. Rebecca, if I got laid off, and everybody knows that there is a 60-day grace period if I'm an L1 visa or H1B visa, and then typically I can find another job if I'm an H1B, move to a different job, or probably if I don't get it, I can go to B2 visa. Let's say, for example, my H1B is expiring on August 30th, though, and I got laid off on August 1st, though. Do I get the 60-day grace period, or I can only stay up to 30 days since my H1B is expiring in August, 30 days from August 1st?
Yeah, so you would only have until August 30th, or when your I-94 expires in that situation. So the grace period is 60 days or subject to your I-94 expiration date. So the 60-day grace period could be shorter if your I-94 expires within 60 days of your termination date.
And if I get laid off and I have an I-94 until, let's say, for example, June of 2026, and I got laid off, my last day of employment is July 31st, okay? July 31st. And however, I'm getting severance pay until September of 2025. I got my last day of work is July 1st, but until July 30th, but I'm getting paid until September 30th, though. Now, there are different kinds of interpretations that whether the 60 days starts from September 30th and whether the grace period starts from July 30th, though. I normally am the intention that it starts at July 30th, especially if the paycheck is telling that it's a severance pay. But there are some companies that I noticed that, especially Amazon and some other companies, they're telling the last day of employment is September 30th, and they're paying normal pay until September 30th. Then I'm telling that then the 60 days starts from September 30th, though.
Yeah.
But there are some companies they're terminating immediately, they're withdrawing the H1B immediately. They are telling that the rest of the 2 months I'm getting severance pay. I am telling them that the 60 days starts from July 30th. Am I right?
Yes. I would say it depends a lot on kind of the conditions of the separation from the company. So from USCIS's side, all they have said specifically about when the grace period starts is from the last date of employment. They haven't specifically addressed what happens in a severance pay situation or anything like that. They've just said last date of employment. So yeah, we do see kind of different types of arrangements when a company may be letting someone go. If it is more of a situation where the worker is notified on July 31st that they are being let go, but they are told that they will continue to receive pay through September 30th for the next 2 months. They're still considered employed during that time. If it's termed as more of a like a transition period, like they are no longer reporting to work and doing the work that they were doing before, but for August and September, for example, they're told that it's a transition period maybe, and they are, during that time, they are to be available to assist with the transition of their duties to someone else, for example, and they will continue receiving separate, pay during those 2 months, and the company still considers their last date of employment to be September 30th. In that case, I would consider that the grace period will start October 1st. But if it is a situation where the last date of, the last date that you reported to work was July 31st, the company, said that, you basically cut ties. Maybe they give you a severance package that is kind of paid out over a period of time, but they they make it clear that you're no longer employed at the company, especially if they have withdrawn the H-1B. That's one thing to try to nail down if you are on a work visa and you're being laid off. I know there's, a lot of things to discuss with the company in a situation like that, but try to get an answer from them on whether and when they are withdrawing the H-1B petition. Definitely when they withdraw the H-1B petition, you will need to consider your 60-day grace period in effect from that date. But there have been cases where, we have submitted a severance paycheck that, USCIS, even if it was a little bit past the technical 60-day grace period, a little bit past the exact 60 days from when the last date of employment was, if the employer did not withdraw the H-1B yet, or if in their withdrawal they didn't specify to USCIS what the last date of employment was, and if kind of paychecks are generally submitted that are within about 2 months of the transfer application being filed. We have seen situations where a transfer application has been filed a little bit outside the technical 60-day grace period, but USCIS has accepted it if they see a pay stub that is within 2 months of the application being filed. Sometimes even when it has the word severance on it, and we haven't seen too much pushback from USCIS in those situations so far. We don't know if that will change under the current administration. We do already know that, they are reconsidering the B-2 policy, potentially change of status policy because of the update to their website. But yeah, it's always best to kind of consult with an attorney to kind of go through the exact sort of terms of your termination from the company and the dates, the different pay statements and what they say on the pay statements, the dates on those pay statements, to try to get an idea in your situation of what you can consider the grace period and whether it's safe to potentially file with a severance paycheck.
Let's go to questions. The question that is coming with Umakant is that it's good that they are paying attention to these scammers of the EB-1A. Definitely, it is definitely good for them to pay attention. But the problem is that even those people who got the green card through EB-1A already with these scammers, though, will be affected, though. If they revoke the I-140 for fraud, they can revoke the green card also. This administration can and probably may take on doing that for the people who are already got the green card for EB-1A, though. For those people who have contemplating and applying an EB-1A for these kind of things, we recommend stay away from these agencies. Don't go with these agencies. Don't stick with these agencies. And if you have already filed the adjustment of status, you may want to consult an immigration lawyer to see if you want to continue with it or if you want to withdraw that application. Please consult with an immigration lawyer. Question that is coming from Pawan Kalyan, that his daughter is a 6-year-old, is an US citizen. Is a global entry a good thing? Definitely global entry may work out. I mean, last time I landed in the airport, my wife got the global entry. I don't have a global entry. My wife was telling me that she will go get past me and then she will get it past her. It so happened that the global entry was 6 minutes, mine was only 2 minutes. So definitely it may help in some people. Now, if you have a global entry that US citizens don't have to use it if the line is longer, it may help, definitely. But here is one thing that we are very concerned, that the non-immigrant visa people are also eligible for global entry. However, we want them to be very careful, though. Let's say, for example, if you have a passport stamping with company A, and now you're coming to work for company B, you have an I-797 approval for company B, though, they don't do anything in the global entry. They give an I-94 with company A's expiration. That's a problem for us. Let's say your passport is expiring in 3 months. This question is coming from Stephen from YouTube, and it's also related somewhere to global entry too. So definitely there is no problem in entering United States if your passport is expiring within 3 months. However, as soon as you enter into the country, check your I-94 to see if the I-94 is expiring within 3 months, let's say your passport is expiring on September 10th of 2025. Let's say your H-1B visa is expiring in 2027 September, and let's say your H-1B 797 is also expiring in September 2027. When you enter into the country, make sure that the I-94 has been given until September 10, 2027. The reason is that they may only give until September 10th, 2025, because your passport is expiring if you come with a 3 months passport. And also, especially for the global entry people, that they most probably only give on that one. So if you check it though, there are multiple ways you can extend it. Either once you extend the passport visa, you can just step out to Mexico and come back. That's one way of extend it. Or you can apply the extension, but don't come to this YouTube channel or to our daily conference call in October of 2025 and tell me that your I-94 expired. That is a problem though. If you tell us before September, then it's we can fix it. There are many easy ways to fix it. So that's the only concern. So Stephen, you can travel, you can come back, but make sure once you come back, you extend the H1, you extend the passport immediately. And if the I-94 is expiring within 3 months, though, may have to leave the country and come back.
Yeah, actually, along the lines of global entry, I have actually been recommending for non-immigrant visa holders to avoid it if possible. We have already had more than one, like a handful of incidents just this year with people who use the kiosks and have a work visa, and they confirmed that they went into the system and linked their global entry account to their current work visa, and the kiosk still issued them a visitor status on their I-94.
Ugh.
And in some cases, they don't find out until months later when, when they're coming to us to, ask, is it okay to travel or file an extension or something like that, or until we get an RFE in some cases, because they weren't aware. And while, even if you catch it pretty soon after coming in, the solution used to be contacting CBP deferred inspection to get them to correct it. That used to be relatively simple under the previous administration. There were a lot of CBP deferred inspection email addresses, and it wasn't required previously that you get it corrected by the same port of entry you entered from. And so you could email, any port of entry and they could get it corrected for you. It has become much more difficult already this year to get an I-94 corrected from CBP port deferred inspection. There are multiple ports of entry now that are saying we will only correct it if you entered through this port of entry or if you live in this jurisdiction. And even the ones that are willing to correct it by email are taking closer to like 3 weeks and requiring multiple follow-ups, whereas it used to just take a few days and, a single email, which is definitely, this is kind of the tone of CBP under the previous Trump administration. CBP under the first Trump administration was very uncooperative. And so it seems like they are kind of returning to that stance. So at least for my clients, I've been telling them just wait in line, go through the line, and show your documents to an actual officer to make sure your I-94 is correct.
Nikita has this question. She has a green card and she wants to travel. Does she need to fill any forms, do any formalities? Absolutely nothing. You take your passport, you take your green card. I don't have to tell you that you need to do that. And then you travel. As long as you travel, you're coming back within 180 days, you have no problems. If it's 1 month, 2 months, 3 months, 4 months, absolutely no problem. Do you need to have a job when you travel? No, you don't need to have a job when you travel. Even if you are jobless, you can travel. Absolutely. Now, VVM has another question. He has some old parents that he needs to take care, and he wants to spend 2 years in India, and he wants to come back. Of course, everybody knows that there is something called re-entry permit that allows the person to stay up to 2 years outside the country and still not lose the green card, though. Now, it's taking more than 1 year to get an advance re-entry permit. I'm sorry. It's taking more than 1 year to get a re-entry permit at this point of time. I want you, if you ever want to use that though, I want you to apply for the reentry permit and don't use it. That's number one advice. Apply for it, but don't use it. Now, other thing is that if you apply for reentry permit and you travel outside the country, please do come within 6 months. If the reentry permit is not approved, if the reentry permit is not approved, do come in within 6 months. So if you apply for a reentry permit in June and and you are in December of 2025, your entry permit it does not come through. You come into United States, spend at least one day and go back. Now, what I tell people is that even if you get the reentry permit, though, please try to come within 6 months, at least for one day, though. There are a lot of negative consequences, though, if you don't come in. You lose the amount of time that you accumulated for the green card. You will start all over again the 5 years. If you spend more than 5 years, more than 1 year outside the country with the reentry permit, you can do it. But it will create a problem for your citizenship at a later date. You will start all the 5 years again. If you make that 6 months trip, every 6 months you make one trip, you will be in a much better position. You can make it if you are financially strained, you can do one thing. There are times of things where the airfares are more cheaper to come into United States. And when the cheaper airfares, the other things are that you get a lot of seats, empty seats. You can even sleep in those things. Now, if you can afford it, and you are that kind of guy, I am. I want to travel luxuriously. If I travel, I don't want to travel. So you can always buy a business class ticket. Please, let me tell you one thing. It's worth. We are not good people. We are immigration lawyers. And whenever you are in trouble, we make money. Really, we do. I'm sorry to say that we do. And it's better that you stay away from us and take care of the things. So for that, I would travel within 6 months into United States to get the green card later on. Now, I want you to file the reentry permit, though. The reason I want you to file it is that because if you don't file it, you go travel, you spend more than 6 months, and at the last minute, you don't want to come back, that's going to create a problem. I want you to file it, but not use it.
There are several questions about advanced parole and whether it's safe to travel on advanced parole. For the most part, yes, we haven't seen many issues with people traveling on advanced parole. The main thing, of course, is that your I-485 application still needs to be in process at the time you're entering the US, and you need to have the I-485 receipt notice, and you may be put in secondary inspection while they check the status of the I-485, but that's not anything new. That has been happening for several years. So just expect it to take longer than usual to get through immigration. There was one question from someone asking, is it safe to travel on advanced parole if they have had a DUI in the past, even if it's been expunged? I would recommend against that travel in that situation. Even if it's expunged, and even though technically a single DUI is not a ground of inadmissibility or a deportable offense, right now the government is looking for any reason to keep people out of the US. And advanced parole, even though you are granted it, for 5 years, when you apply for it and it's approved, technically it's still discretionary. And we have seen more kind of CBP officers really exercising their discretion, sometimes beyond what they should be at the borders, and asking questions they shouldn't sometimes. And I can definitely see an overzealous CBP officer finding out about your DUI and using that as a reason to deny your entry just based on discretion, because advanced parole is still technically discretionary. So I definitely wouldn't recommend traveling on advanced parole in that situation. There was also a question of, is it safe to travel on advanced parole if you don't have a job right now? So if you are the principal applicant, the I-140 beneficiary, basically, one of the requirements is that you are supposed to maintain a continuous job offer from the time the I-485 is filed until it is approved. So if you don't have a job at the moment, but If you have documentation of a job offer, that is probably fine. But if you have no employment and no job offer at the time you're entering the US, I would say in the past, I would say it would probably be okay. But with the amount of questions that CBP may be asking you at this point, I probably also would not risk traveling on advanced parole if you have no job and no job offer, because technically in that situation, the I-485 could be denied. And so they may deny you entry on the advanced parole if they find out.
AG Suresh is asking this question. He's from Facebook. His I-140 is approved. Can he travel and stay for a long period of time? Can he come back? Will there be any problem for the I-140? I'm assuming that he's planning to move back to India. He has not filed the adjustment of status. He has not got the green card. In that case, you can move back to India and you can come back after 10 years and you can come back on H-1B if your prior date is not current, which most of the prior date is not moving. Yeah, I don't see any problem for you. We have a problem for the green card holders leaving the country, but you're not a green card holder. You're an H-1B. You're a non-immigrant status in the United States. I do not see any problem for you traveling. Reshma is asking this question. What kind of questions you're noticing for the people who are a green card holder who are coming back to the United States? Reshma, for the people who are coming within 6 months after they leave the country and coming back, no questions are asked. I mean, even if they are asking questions, it's like, when people come in, I greet, hey, you want to have a coffee or something. It's just a casual conversation, though. But we have not noticed any problem whatsoever at all, unless there is some criminal history, or if they have traveled for more than 6 months outside the country. No questions asked. They're only trying to find out whether you are Reshma or you're not. If you're not and you're faking it, then you should be deported. Of course, we all agree on that one, right? So that's all they are figuring out. Not a problem at all. No problem at all.
Vikram is asking if he can get a 7th-year H-1B extension in a transfer application using the previous employer's approved perm that was filed more than 365 days before the end of his 6-year limit. Yes, as long as that previous employer is willing to keep the perm approved. And it kind of depends on the timing. So if the perm is approved, but it is still within the 6-month window after the approval date, then just the perm approval is probably all you need in order to get the 7th-year extension. If it's been more than 6 months or it's nearing the 6-month mark, in order for that perm to remain valid, the company would have needed to file the I-140 petition based on it. And then you would include both the perm approval and the I-140 receipt notice in the transfer application. So depending on when the perm was approved and the level of your previous company's willingness to support the perm and potentially file an I-140 based on it, that could affect it. But if those are all true, the company is willing to keep it approved, potentially file an I-140, then yes, you can use it for a new employer's transfer application.
Ray has this question from Facebook. He's asking it. Ray says that, are people getting H-1B stamping as usual, or are there been any delays, or are there been any denials? Definitely a lot of scrutiny, guys, in the H-1Bs. Like, a lot of scrutiny in F1s, a lot of scrutiny in B2, a lot of scrutiny in everything. Do I need to explain you guys that Trump administration is anti-immigrant, guys? If ever anybody in United States or anywhere says that Trump administration is more favorable than is a very favoring immigrants, I definitely want that guy to see a doctor. What do you agree on that, Rebecca?
Yeah.
Somebody says Trump administration is favorable to immigrants, they need to see a doctor, because there are, and then comes another question, like, people are asking me a question with regards to citizenship. What do you think of citizenship? Is there any ruling? No, there is no ruling for citizenship at this point of time. There is no ruling at this point of time. Of course, which way the Supreme Court is going to rule, lawyers have different opinion, guys. Some people say it's going to come in the favor of immigrants. where there will be a nationwide injunction. Some people say it will be court-wise and a later final hearing. There are a lot of debates with the lawyers will say, some lawyers will say the decision is going to come in immigrant. I say that it's going to find immigration papers, but there are some lawyers who say otherwise. Both are competent lawyers. But when any lawyer or any immigration person is telling that Trump administration is in favor of immigrants, well, they need to check with the doctor. So Ray, don't go for stamping if you can avoid.
Gaurav is asking if he has a pending I-485 and faces job loss, and his priority date becomes current, would he still get the green card? So this is kind of along the lines of the requirement of a continuous job offer that we mentioned earlier. So technically, you are supposed to always have a job offer from the time the I-485 is filed until you get the green card. There are situations where we have seen people have gaps in employment. A gap in employment may not be a problem if you have a job offer that covers that period of time. So if you know that you're going to be laid off, for example, and you can secure a job offer that covers a gap, or a job offer letter that covers the gap, then that can continue to support the I-485. But if there is kind of a sudden unexpected job loss and there isn't time to secure another job offer without there being a gap, it's just sort of a matter of how much USCIS looks into it when your priority date becomes current. In the past, we have seen USCIS sometimes send RFEs asking for maybe an updated medical exam and like your past 5 years of employment history. If they ask something like that, then it's possible that an employment gap would come to their attention, and that could be a problem for your I-485. Or if they schedule you for an in-person interview, which is not across the board right now, but it is happening more frequently under the current administration, then that gap in employment or a gap in a job offer could come to USCIS's attention, and it could be a problem for the I-485.
Vishal has this question. Can a H1B spouse can revoke H4 without the divorce being finalized? Absolutely not. If they write a letter saying that revoke my wife's H4, they won't accept it. And if they do any fake things like writing on behalf of the wife, that will be criminal action on that particular person, because only she can withdraw the H4. Nobody else can withdraw the H4. Question that is coming from from Deepthi on 485 application. Can I file 485 on H4 EAD as a primary person? She's an H4 ED. Can she file? Absolutely, you can. No problem. Absolutely no problem for you to file 485. When you're an H4 ED, you don't have to be on H1B or L1 to file the 485 main applicant. This question is coming from Admin Mikhair. Can we do something to write to the local senator, local government bodies to remove family members to count on the green card? Well, it should go to the federal government right now. And we are not promoting that kind of letters that much as we used to in the Biden administration, because we don't think so this administration is going to do it. Why waste your time and energy when we know that they're not going to do it? We know Trump administration, we know Stephen Miller, they are not in favor of removing the family immigrants. They are not in favor of increasing the number of green card holders coming on employment-based immigration. So definitely it's not going to work right now. You can write, but it may not be able to help you. Yeah, should have been done in Biden administration.
We have a question from someone who's asking about their wife who is on H4 EAD and was selected in this year's H1B lottery. When will her status change, and when can she switch back to H4 EAD? And would there be an employment gap in the transition? So if the H1B petition was filed requesting a change of status, and if it is approved before October 1st, then the change of status from H4 to H1B will automatically go into effect on October 1st, as long as she has not departed the U.S. From the time the petition was filed until October 1st. So as long as she stays in the US, the petition is approved by then, her status will automatically change from H4 to H1B on October 1st. If your intention is for her to move back to H4 EAD, maybe so she doesn't use up the H1B 6-year limit, or she wants to continue to use the EAD because it's more flexible, but she wants to ensure she gets counted in the cap, then yes, still file it as a change of status, let it go into effect October 1st, and then if you want to move back to H4 EAD, the easiest way would probably be to travel. If she still has a valid H4 visa in her passport, she could come back into the US, even from a 2-day trip to Mexico or something like that, come back into the US with her H4 visa and your H1B approval notice and her marriage certificate, and re-enter the US, and she would be issued a new H4 I-94 at CBP, and she would be back in H4 status. She could continue using her EAD, her H4 EAD in that situation. So that would be the probably quickest way to get back into H4 EAD. That would avoid a work authorization gap. The other way, if she doesn't want to travel, would be to file a change of status from H1B back to H4, but that would be filed on the I-539 application, which if it's filed apart from an H1B petition, it can't be processed in premium processing and might be pending for several months. She could work in H1B status until then, but wouldn't be able to use the EAD until the H4 change of status is approved. And so if it's something where she wanted to continue operating like a side business on the EAD, she would have to stop doing that until the H4 change of status is approved again.
Question. I've been interviewed for, this is from Ganapati. I've been interviewed for 485. It's been 6 months, no decision yet. I want to travel in EAD and AP. I don't see any problem. If there was some issues, then definitely it could have been an issue until now. So I don't see any problem in you traveling outside the country on advanced parole. A question on, can I travel on STEM OPT? My general advice is no. That's a very sensitive issue, a lot of scrutiny going on. If you want to, I would recommend that you definitely consult, make sure you have the pay stubs, make sure you have a job, you have a proper job and documentation, then only go. And still, I will prefer you don't go. But if you have to go, then definitely consult a lawyer, make sure all the documentation, all the documentation is good.
Srinivas is asking, is it sufficient to file the H-1B transfer within the 60-day grace period, or does the employee have to start working within the grace period? It's a little bit up in the air, but I would say you would need to start working at least by the end of the 60-day grace period. So filing the transfer application doesn't become kind of a blanket authorization to remain in the U.S., not doing anything, because the H-1B, you are considered an H-1B status during the duration of the grace period, and in order to maintain H-1B status, you have to be working for an H-1B employer. The 60-day grace period, of course, you're not working for any employer. That's kind of the point of the grace period, is that after you're laid off or terminated or leave the company, there's that 60-day period of time where you can still kind of be considered in H-1B status, but not working for a company. But beyond that, I would say if the transfer application is filed and pending on day 25, for example, maybe you can hold off on working for the next month or so, or joining that company for the next month. But definitely by the end of the 60-day grace period, I would say you need to have joined that company in order to be maintaining H-1B status.
Lucky is asking this question. I'm getting promoted to technical architect from software engineer. Do I need an amendment? We can't tell by the titles itself, though. But if the job duties are changed significantly, definitely you need to file an amendment. But if the job duties are just only, if the job duties are only just minor change, though, then definitely you do not have to file an amendment.
We have a question on what would the grace period be for GCEAD holders in case of a job loss. So technically there isn't a grace period. So that is one thing that is kind of a misconception because everyone is so used to the 60-day grace period for H-1B status. There really isn't a grace period for that continuation of a job offer requirement on the I-485 side. So if you're in a situation where your I-485 is going to be pending for several years because of priority date retrogression and that kind of thing, and you want to kind of have a backup in case you do find yourself unexpectedly without a job, you may want to consider those, like even before you find yourself in that situation. There are some situations that are where it is more flexible. For example, you can be self-employed and that can count as your I-485 job offer. You can have started a company. If you have the GCEAD, you can start a company. And if that company can support, a full-time position in a same or similar field as the one in your I-140, that can count as the qualifying employment for purposes of keeping the I-485 valid. And so if you do think that unexpected job loss is a possibility, or you just want to prepare yourself for that situation, you may want to consider some of these kind of backup options so that you are prepared in case you find yourself in that situation.
Second. I have an I-140 filed. Sorry. Anurag has this question. Can my employer file I-140 even though I'm not working for the company? The answer is yes, they can file it. You don't have to be on the payroll of the company. Our EB-1 lawyer, Mr. Kareem Javani from our office, he does a lot of EB-1s other than Rebecca in our office. He does a lot of EB-1s. He's reporting that there are a lot of scammers. There are a lot of scammers in EB-1 that have paid $40,000 for these agencies who then got their EB-1A denied. And they guaranteed those things, making false approval stories in LinkedIn and other those things. I'm not much worried about the people who got denied. I'm more worried about for the people who got the approvals also. The reason is that even after the approval, they may revoke the green card. They may deny the. They may revoke the. They may withdraw. They may they may deny the 485, and it may have a more negative consequences because if they hit you with a misrepresentation that you knowingly paid money to get an awards to file for the EB-1A, they may bar you forever coming into the United States. If you have filed any fraudulent application, knowing it's a fraudulent application, you have a permanent lifetime bar to ever come back into the United States. That is the most worrying thing that I have.
We have a question about automatic revalidation traveling back from Mexico. Is the original I-797 approval notice needed, or is a copy sufficient? So far, a photocopy has been fine. Ever since the pandemic, since COVID, they've been accepting copies of the I-797 approval notice. And so there aren't many situations anymore where you actually need the original I-797 approval notice. The main situation is when you're renewing a driver's license at the DMV, they seem to still request the original. So we haven't heard anything so far about CBP changing their policy on accepting photocopies. But if you do have the original, it might be a good idea to carry it plus a photocopy.
Jashwant is asking a question. He is on H-1B, is expiring in May 2026. His wife is in India and she's going to be in India for a while. Can he file H-1B, H-4 and EAD together? No. If your wife is in India, you can't file H-4 for her. You can file a H-1B and then she can get the H-4 stamping there. Or when she comes back into the United States, assuming that her H-4 is expiring in May 2026, already have a stamping, she can show your H-1B approval and then she can get a H-4 until your H-1B expires. You can do that. I mean, there are a lot of times the CBP will give an H-4 until a lot of times they give a H-4 until the time your H-1B expires.
Mazar says his priority date has been current the past 2 months and there is no action yet. What are his options and how soon will he hear from USCIS? So one thing to make sure of is that your priority date is current according to Chart A. So there's two charts for employment based on the visa bulletin. Make sure you're looking at the final action dates chart, chart A. If your priority date is current according to that chart for the past 2 months, yeah, definitely follow up with USCIS if you haven't already. Call their customer service line. And if there isn't any further action, Stephen Brown in our office has filed I-485 delay litigation cases in situations where the priority date has been current for, I think, 2 months or less in some cases, to basically compel USCIS to take action on the case. Because what you don't want is for, especially if your I-485 has been filed and pending for, more than 6 or 7 months, that's about the amount of time needed for all the other processing to take place, for them to, review your medical exam and do the background check and any other processing. Especially if your application has been pending for a couple of years and it's becoming current now, you want USCIS to act on it and approve it before the priority dates retrogress again, potentially. So if you are concerned, you can reach out to USCIS. What you want is to get their attention on the file. If calling USCIS customer service, putting in a service request doesn't work, consider scheduling a consultation with Stephen Brown in our office to see if you have a good case for an I-485 delay case, which would kind of compel the government to take action on it while the priority date is still current.
Manas Bhattacharya has this question: for those people who have been requested for biometrics for H-1B extensions or transfer, what is the update? We haven't seen any denials for the H-1B. In fact, we have also seen approvals for those people who have this minute, there are some criminal records for which they've been called for the biometrics. We haven't seen any arrest unless they have some drug offenses or some major offenses. For the DUIs and some small offenses, we haven't seen any major issues for those people. And we're not encouraging any people to do any criminal activity, but if they have already done, that's what I'm advising. Question that is coming from Anupam Sachdeva. That's a good question. This person filed for a marriage-based green card, and it's been 16 months that it's been pending, and the application was filed as soon as this person got married. His or her question is that if the green card is approved after 24 months, do I get a 10-year, which is a permanent green card actually, or will I get only a 2 year green card? Now, I just want to let people know that if people do get the green card based on the marriage, and the marriage within 2 years after the marriage, if they get the green card is only valid for 2 years. And within those 2 years, 90 days or 120 days before the 2 years, you have to go back to the USCIS. You have to prove that you're married together and you are staying together, and then they will give you the permanent green card. That's how it works out. Answer to you, Anupam, is that if you get a green card after 2 years, you get a permanent green card. It is not going to be a 2 year temporary green card. It's going to be a permanent green card, and which will be valid for 10 years. Technically, it's valid for 10 years, they say, but it's kind of valid forever. You can renew it by going online and filing an I-90. It's so easy. You don't need a lawyer for that. You just file an I-90 form online. It's so easy. Of course, before you hit 10 years, I'm expecting you'll get a green card. But as it's right now, if you get a green card after 2 years, then you will get a permanent green card.
Karthik is asking for the H-4 EAD auto extension. Does the H-4 have to be approved, or is just the H-4 being filed enough? So this is an important difference between H-4 EAD and a lot of other EAD types. It's not automatic. The H-4 I-94 has to be extended in order for the EAD auto extension to apply. And so most of the time that will require traveling outside the US and coming back in to get the extended H-4 I-94 at CBP if USCIS is taking a long time with the I-539 application. So we do have an article on our website that addresses this specific situation if you are considering travel and all the things that you need to consider and keep in mind. So you can check that article if that is something you are considering.
Karthik Sundarapan has this question for automatic EAD extension, 540-day rule. Oh, you already said, okay, sorry about that. Give me 1 second. Chaitanya Reddy has this question. His name is Venkat Chaitanya, is a first name, and he want to change it to only Chaitanya, drop Venkat off. Well, a lot of people want to drop Venkat off. Even I dropped my Venkat off. My name was, yeah, you can, it's a very simple process. If you want to drop it, you have to file a court case. It's very simple. Some lawyers will charge about $500 or even up to $1,000, and you get a court order to change the name. And you can then take that one to the driving license office. Then you can take that one. He's a green card holder. You can take that to you have to file an I-90 form to change it on the green card. And on the passport, I don't know if I'm going to do all that though, because you have only 2.5 years left. So I would wait until citizenship comes in. When you get the citizenship, you can take the citizenship certificate as an evidence and you can change it at the Social Security. And of course, you get a new passport issued on the new name. So I will wait, but if you don't want to wait, you just have to go to the court. And it's a very simple process in getting the name changed, but then you have to change it in the Social Security, then you have to change it in the driving license, you have to change it in the passport, and you have to change it in the green card. These are all the 4 steps that you need to do. Anything else, Rebecca?
No.
Thank you guys for coming. The next Zoom call, the next YouTube session will be on Tuesday, but if there is any updates, we do bring in, please subscribe to our news channel. We do have a daily free Zoom conference call every day where we give 30 minutes of free advice. You guys can come and ask the questions. The link is provided to you. The timings are provided to you. We are doing that free Zoom call session from past 13 years. You can participate in that. And if you want to speak with me, Rebecca privately, or any of our office people, you can block a time. My appointments and Rebecca's appointment, all other colleagues of our appointments are available online. You can access it and you can block a time that is suitable to you. Thank you very much. Thank you, Rebecca.